our community here today to honor and remember Justice Ruth Bader Ginsburg, a towering figure in American law and American life. But today is not only a remembrance, we also look forward to consider what her legacy is for us as lawyers and as citizens, because her work is not done. Justice Ginsburg is most well known as a trailblazer for women in public and economic life. Her revolution was in some ways so successful that many women take for granted the access that she fought for. We can all go to law school. We can all get jobs at big law firms or in-house legal departments. But we don't have to look far to see that her work is unfinished. Women are being pushed out of the workforce by COVID in wildly disproportionate numbers, eroding whatever economic security they had built for themselves. Many of you sat through your 1L year without seeing a single woman at the podium. All of us saw our own alum on the VP debate stage Wednesday night being interrupted and condescended to by her male opponent, and then being attacked the next day for looking annoyed or angry or any other number of gendered terms that were hurled at her all over social media and conventional media. We are far from finishing the work that RBG dedicated her life to. On some level, we all know this, even if it's not center of mind every day. And I think that that's why she became such a cultural icon. It's so moving to me to see images of little girls wearing lace collars, to see my spin instructor wearing a plank-like RBG tank top. As far as we have come, we all need role models to inspire us, and RBG was just that for so many. And my hope is that she will continue to be a role model for us. When asked once how she wanted to be remembered, Justice Ginsburg said, as someone who used whatever talent she had to do her work to the very best of her ability and to help repair tears in her society. This is an example we can all aspire to, and I hope that our gathering here today inspires you to do just that. We have 4 amazing panelists today drawn from our faculty who are going to talk about Justice Ginsburg's life and legacy. Scott Dodson is the James Edgar Hervey Chair in Litigation and the Jeffrey C. Hazard Jr. Distinguished Professor of Law. He is also the editor of a book on the legacy of Ruth Bader Ginsburg, and he's going to provide some background and context on Justice Ginsburg's life and her time on the court. Radhika Rao is a Harry and Lillian Hastings Chair and Professor of Law at UC Hastings. She teaches and writes on reproductive rights, and she will discuss Justice Ginsburg's legacy in that field. Joan Williams is a Distinguished Professor of Law and UC Hastings Foundation Chair and Director of the Center for Work-Life Law. She will talk about Justice Ginsburg's contributions to workplace and employment law. And finally, Joel Paul is the Albert Abramson Professor of Law. He will pivot to discuss the implications of Justice Ginsburg's absence on the court and what this means for the court itself and the various policies under discussion to change the structure of the court in the event that her seat is filled before the election. Following their presentations, we will open the floor for your questions, reflections, and discussions. And so with that, I'm going to turn it over to Professor Dodson.
Well, thank you, Jodi, for putting on this great event. I'm really delighted to be here today. Although it seems sometimes like the rest of the world is crumbling, I find that it can be comforting to think about people like Ruth Bader Ginsburg, these bright beacons whose accomplishments and compelling personal stories really cut through the fog and even bid us to follow. So as Jodi mentioned, I put together a book about her back in 2015. There's lots in the book about what most people know her for and what I'm sure others on this panel will also talk about, which is her fierce efforts for gender equality. And that should come as no surprise because for most of her life, she was a driven woman living in a man's world. And just because she was a woman, she had to fight like no man to earn the respect she deserved as a person. So let me start with a few anecdotes about Ginsburg to put her accomplishments as a jurist in perspective, and then maybe I'll say a few words about her as a jurist that you might not hear elsewhere. So I'll start with Cornell, which is where she went to college. She did a fair amount of studying in the bathroom at Cornell to avoid being seen as nerdy and uncool. As it happens, she succeeded. She finished first in her class, but not at the expense of a social life, because Cornell was where she met Martin Ginsburg, the love of her life. She and Marty lived what could only be called a Rob Reiner relationship, a 56-year storybook story. On their wedding day, Marty's mother offered Ruth a little advice on the secret of a happy marriage, that every now and then it helps to be a little deaf. The advice was so good, Ruth would recall later, that she followed it not just in dealing with Marty, but also with her colleagues on the court. The secret sauce of their marriage, by the way, was that they always supported each other. Marty once said that the most important thing he'd done was enable her to do what she did. That was undoubtedly true, but she also did the same for him. I once heard a story that decades later, when Marty was facing a losing battle with cancer and was almost too sick to stand, Ginsburg would stand behind him in the kitchen and physically support him upright so that he could cook dinner for the family. In the 1950s, the family of three, at that point they had a baby girl named Jane, they all moved to Massachusetts, where Marty and Ruth both enrolled in Harvard Law School. Harvard had not admitted women students until 1950, and they were still an oddity in 1956 when Ruth matriculated with 8 other women out of an entering class of 552. Dean Erwin Griswold hosted a tea for the women and pointedly asked each why she occupied a place that would otherwise have gone to a man. Shortly after that indignity, Marty was diagnosed with cancer. The doctors told the couple that his chances of survival were very slim, but they decided to try everything, including 2 operations and daily radiation therapy. That left Ruth with a 3-year-old child, a sick husband, and law review, all of which she did with aplomb, as well as collecting notes for Marty's classes and typing his papers. Marty survived, graduated with honors, and was hired by a New York white shoe law firm. So the whole family moved to New York. Ruth still had 1 more year at Harvard, though, so she asked for permission to complete the Harvard graduation requirements at Columbia Law School. Despite frequently granting male students such permission, Dean Griswold told her that she had not made out a case of exigent personal circumstances, and he denied her request. So she promptly withdrew from Harvard and transferred to Columbia. Many years later, Harvard offered her an honorary degree, but only if she would renounce her Columbia law degree. And she responded that she had only 1 earned law degree from Columbia. She treasured it and would have no other. Ginsburg graduated first in her class from Columbia, but she couldn't get hired by a law firm. She was recommended for a Supreme Court clerkship with Justice Felix Frankfurter, but he wouldn't interview her. She was turned down by Judge Learned Hand, who said he couldn't hire a woman because he couldn't swear in front of her. She finally got a clerkship with Judge Edmund Palmieri, but only after Gerald Gunther, who had recommended her, said that he would stop sending Palmieri clerk recommendations if the judge didn't give her a chance. Ginsburg viewed these experiences with some grace. She observed that her status as a woman, a Jew, and a mother was a bit much for prospective employers in those days. That didn't make it right, of course, but she understood the pressures that society put on everyone to enforce gender roles. Those experiences no doubt created the fierce gender warrior that she became and fueled the tremendous victories that she accomplished as an advocate and as a jurist. But since we're all kind of law nerds here, I'd like to switch focus to something that you may not hear as much in the popular news, but which was in some ways her most compelling approach to judging, in my view. And that was her respect for precedent. Let me be very clear about this. Of all the justices with whom she served, she was the one who most fairly read and most closely adhered to prior precedent in her opinions. In fact, a recent study concluded that between 2005 and 2020, she never wrote an opinion for the court overturning or even altering precedent. Her fidelity to precedent was most apparent in criminal cases, especially cases involving sentencing and the confrontation clause, which often led to alignment with Scalia and Thomas and against pragmatists like Kennedy and Breyer. But let me give you a quick example from my own field of federal jurisdiction, and I warned you this was going to be a little nerdy. In a 2006 case called Arbaugh, written by Ginsburg, the court developed a principle that judges should not hold a statutory limit on court power to be jurisdictional unless Congress clearly said so. Then in 2007, the court decided Bowles versus Russell, written by Thomas, holding that the statutory deadline to file a notice of appeal in a habeas case was jurisdictional despite no clear statement from Congress. Ginsburg dissented in that case, pointing out that Bowles could not justify its departure from Arbaugh. She was right. The best the majority could do was point out in one sentence, buried in a footnote, that some of the features of the cases were different. But the majority didn't explain why those differences mattered in the least. A few years later, in a case called Reed Elsevier, the court confronted a case that seemingly put the court to a choice between Arbaugh and Bowles. Ginsburg, however, rejected that path as a false choice. And although she was in dissent in Bowles, in Reed Elsevier, she wrote an opinion that reconciled the two cases based on a close, careful, and faithful read of them. She basically added to Bowles an Arbaugh-compatible justification that the Bowles majority was unable to see at the time. And she was therefore able to preserve both cases intact. And indeed, she synthesized them into a consolidated set of principles that animates the doctrine of jurisdictionality today. Now, respect for precedent has two main attributes that I think reflected Ginsburg's own personality. The first is humility. Respect for precedent is respect for the wisdom of the ages, the wisdom that has been tested over time and that can be too easily overlooked in present circumstances when the risks of myopia and hubris are at their height. And the second is neutrality. Respect for precedent anchors decision-making in opinions generated by all kinds of judges, arriving at all kinds of results and affecting all kinds of policies. Precedent is the key to judicial legitimacy and the neutral development of the law. And Ginsburg was in many ways an activist judge. She undeniably pressed a policy agenda, and those on the left will praise her for it, and those on the right will vilify her for it. But everyone, regardless of political stripe, should appreciate her deep respect for precedent. And that at bottom is why respect for precedent, I think, is so important. It's unifying. Textualists, originalists, instrumentalists can all disagree when it comes to the interpretation of a statute or a constitutional provision. Political partisans disagree about the results in the cases. But we can all come together and bridge those different priors when it comes to reading a set of opinions closely and carefully, understanding how the facts of those cases influence the rationale of decision, and synthesizing them into a coherent set of legal principles. Those skills, incidentally, are what we as law professors strive most to teach to our students. And that is why Ginsburg should serve as a beacon, a guiding light for decades of lawyers, judges, and law students to come. Thanks.
Great, thank you so much, Scott. So next up, we have Professor Radhika Rao.
Thank you. It is such an honor and a privilege to be here on this panel, and I'm so delighted to speak about RBG and abortion. So, as Jodi said, RBG has become this cultural icon, a larger-than-life feminist figure idolized by people everywhere. In fact, 2 years ago, my own daughter considered dressing up as Wonder Woman for Halloween, but she finally decided to go as another superhero, the notorious RBG. And she wasn't the only one. Hundreds of girls dressed up in RBG's signature style, black robes decorated with lacy white collars. But we often forget that when she was nominated by President Bill Clinton to the Supreme Court, RBG was actually seen as a centrist who was viewed with caution by some women's groups. They were suspicious of her because of her critique of Roe versus Wade, and they feared that she would be too conservative. Indeed, Kate Michelman, who was then president of the National Abortion Rights Action League, called RBG's criticism of Roe, quote, cause for concern, and said that the Senate Judiciary Committee should determine whether Judge Ginsburg will protect a woman's fundamental right to privacy, including the right to choose, under a strict scrutiny standard. Full disclaimer, I was an idealistic young woman clerking at the Supreme Court at that very time. And although I was thrilled by Bill Clinton's nomination of a woman to replace Justice Byron R. White, I shared some of the reservations about RBG. I was worried that she was too much of a centrist, too minimalist, that she wouldn't be enough of a crusader. Of course, I was also a Blackmun clerk, and law clerks tend to be very protective and loyal to their justices, especially one like Harry A. Blackmun, who was this warm, grandfatherly figure adored by the clerks for his empathy and for his courageous stance on abortion. Blackmun bore a high price for being the author of Roe, a title he said he would carry with him to his grave. He was picketed outside the halls of the Supreme Court, threatened with death, and even targeted by a bullet shot through his living room window. He was beset on all sides by scathing comments regarding Roe, but the criticisms of Roe seemed all the more cutting when they came from RBG, the celebrated advocate of women's equality. So, what did RBG actually say? In a 1985 article titled Some Thoughts on Autonomy and Equality in Relation to Roe versus Wade, then Judge Ginsburg declared that Roe was weakened by the opinion's concentration on a medically approved autonomy idea to the exclusion of a constitutionally based sex equality perspective. And in a speech she gave at NYU in 1992, just a year before she was nominated to the court, RBG added, the 7-2 judgment in Roe versus Wade declared violative of the Due Process Clause of the 14th Amendment, a Texas criminal abortion statute that intolerably shackled a woman's autonomy. The Texas law accepted from criminality only a life-saving procedure on behalf of the pregnant woman. But suppose the court had stopped there, rightly declaring unconstitutional the most extreme brand of law in the nation, and had not gone on, as the court did in Roe, to fashion a regime blanketing the subject, a set of rules that displaced virtually every state law then in force. Would there then have been the 20-year controversy we have witnessed, reflected most recently in the Supreme Court's splintered decision in Planned Parenthood against Casey? RBG said, a less encompassing Roe, one that merely struck down the extreme Texas law and went no further on that day, I believe, might have served to reduce rather than to fuel controversy. A lot has changed in the 27 years that RBG sat on the Supreme Court. She grew into her role as the liberal voice, the beacon on the Supreme Court. And I changed too. I was an idealist back then, but after all these years teaching abortion and Roe, I've become a realist. Some might say I grew old. And I now see the wisdom in RBG's words. Indeed, you might even say she was prophetic. I'm still not sure whether I agree with RBG's prediction that there would have been less backlash had the court issued a more limited ruling in Roe. Casey was much more modest in its protection of abortion than Roe, yet it seems to have stimulated even more efforts on the part of states to undermine abortion rights. I think the court in Roe thought it necessary to specify a fundamental right and a clear framework in order to send an unambiguous signal to lower courts and state legislatures. Perhaps this was the lesson learned from Brown versus Board of Education, with its more incremental, all deliberate speed formulation, that any ambiguity in the court's ruling would be exploited by those who oppose a decision. I do agree with RBG, however, that abortion cannot be understood without consideration of its significance to women, that reproductive autonomy is inextricably intertwined with women's equality. Unfortunately, the equality rationale was neither argued in Roe, nor would it have been a tenable basis for the court's holding at that time. The only precedents presented in support of the woman's right were Griswold and its progeny, and they all relied upon the constitutional right to privacy. And in 1973, when Roe was decided, gender classifications received only low-level rational basis review. In fact, a year after Roe, the court rejected the argument that pregnancy discrimination constitutes sex discrimination in a case called Geduldig against Aiello. So it would have been incredibly difficult for the court and Justice Blackmun to garner the necessary votes for the result in Roe if they had tried to ground the right in equal protection. But ultimately, I think it mischaracterizes RBG's position to suggest that she opposed Roe. RBG understood the importance of reproductive autonomy to achieve gender equality, as she made clear in her many eloquent opinions as a justice on the court. I believe that RBG was disappointed with Roe because she thought it wasn't the best vehicle for presenting the issues. RBG was an excellent jurist, but her true genius was as a brilliant advocate responsible for path-breaking cases that transformed the law and made people see the world differently. Her strategy was to demonstrate that sex discrimination is a double-edged sword that wounds men as well as women. And her brilliance lay in selecting gender-bending plaintiffs in cases like Frontero against Richardson and Weinberger against Wiesenfeld, military women who wanted equal allowances for their spouses, and stay-at-home dads who sought Social Security payments following the death of their working wives in order to care for their kids. I'm sure we'll hear more about some of these cases from Joan, but on the issue of abortion, if RBG had her way, the court would have addressed this issue in a completely different context, not in Roe, but in a case called Struck against Secretary of Defense. As a lawyer for the ACLU Women's Rights Project, RBG represented Susan Struck, an Air Force captain who became pregnant while serving in Vietnam. Under Air Force regulations, Struck would either have to get an abortion at the base hospital to keep her job or be forced to leave the service. But Struck refused to get an abortion because it violated her Roman Catholic faith. Instead, she wanted to use the vacation days she'd saved up to give birth and then put the baby up for adoption. So this case intertwined the issues of a woman's right to choose whether or not to bear a child, together with equal protection, because no man was forced to leave the Air Force because he was going to become a father, and freedom of religion. In Struck, it was obvious that the government was forcing women to have abortions because of stereotypical assumptions about women's gender roles in childbearing. Struck lost in the lower courts, and then the Supreme Court agreed to hear her case in 1972. So it was on the docket the very same term as Roe versus Wade. If the Supreme Court had been presented with the issue of abortion in this context, I think it would have been forced to confront not just abortion, but also gender equality and religious freedom all together, which probably would have led to a dramatically different kind of judicial opinion. Fortunately for RBG's client, the Air Force waived Struck's discharge and allowed her to remain in the service. But unfortunately for all of us, the case was dismissed as moot. So we will never know what might have been the result. I believe that RBG's criticism of Roe was not rooted in her disagreement with the fundamental nature of a woman's right to autonomy over her own body, but with her disappointment at the unidimensional character of the court's abortion jurisprudence. RBG aspired to construct a more complex, three-dimensional abortion jurisprudence, one that recognizes the intimate relationship between reproductive autonomy, religion, and gender equality, and that acknowledges that a woman's right to make these choices is essential to her freedom of religion and her equal citizenship stature. RBG saw the complexity of the real world, in which women have jobs, religious beliefs, and struggle with their choices, whether to bear or beget a child. And all of these things are interconnected. In fact, she lived this complexity in her own life, and she will live on in our own hearts. So thank you.
Thank you so much, Radhika. And next up, we have Professor Joan Williams.
Many thanks, Jodi. I'm so delighted to be here today with my cherished colleagues talking about a person that we all feel really strongly about. Ruth Bader Ginsburg's central philosophy has been very, very influential in American life in ways that are, I think, widely understood. At the core of her vision of gender equality was deconstructing the breadwinner homemaker dyad. She went about doing that very methodically in American life, because that dyad was built into American life in various deep ways when she started her agenda in the 1970s. Radhika mentioned Weinberger versus Weisenfeld, one of RBG's favorite cases. And that shows you that case involved a father who wanted to take Social Security Social Security survivor benefits to care for his child. And it was, that was not available at that time because the breadwinner homemaker dyad was built into Social Security and other government programs so that only widows could take that survivor benefit. RBG got that struck down as a violation of equal protection. So she set about deconstructing this breadwinner homemaker dyad in government programs, also in government jobs. Frontiero versus Richardson involved a female soldier who wanted to get medical, dental, and housing benefits for her husband. Well, male soldiers got those benefits automatically for their wives on the assumption the wives were dependent. But for women, you had to prove your husband was dependent. And that also was struck down by equal protection. That was one of many cases in which RBG litigated on behalf of male plaintiffs. Both of those were. And a third one was Orr v. Orr, because the breadwinner homemaker dyad was also deeply embedded into divorce law. For example, alimony was only available for women. And in Orr v. Orr, that was struck down as an equal protection on the basis of equal protection too. So she was really driven by the idea that not only is the homemaker role oppressive for women, the breadwinner role is oppressive for men. And one of the other really important contributions of RBG was to actually to disseminate the philosophy of gender equality that she inherited from Olof Palme. And I was trying to get my cat in here because my cat is named Olof Palme, but then he proved too distracting. But Olof Palme was an amazing Swedish prime minister, both an amazing social democrat and an amazing feminist. And I got this cat shortly after in 2016, and I thought, like, I'm going to live in a social democracy because cats always rule. So Olof Palme was a role model for RBG, also for me. He, in 1970, while he was prime minister, he was later murdered actually, but while he was prime minister, he delivered a manifesto called The Emancipation of Man, and said that in order for women to be emancipated from their antiquated role, the men also must be emancipated. The culturally conditioned expectations of an individual on account of sex act as a sort of uniform. And in fact, the emancipation of men, he said, was the linchpin of the struggle for sex equality. And, you know, he was right. I have argued as well for putting masculinity at the core of a feminist analysis. And because gender pressures on men have changed very little, what we see is what is often called the stalled gender revolution. Men's household contributions stalled out around 1985. And about 5 years later, so did women's workforce participation. And mothers still do spend nearly twice as much time as fathers doing core household tasks and caring for children as the primary caregiver. And as Radhika mentioned, 1 out of 4 American women is now thinking about either dropping out of the workforce or rolling back their careers. And one recent study found that 1/3 of fathers have received a promotion while working remotely, but only 9% of mothers. So RBG was prescient. If you don't change roles for men, you will not change roles for women. And what's happening under COVID is that men's work time is remaining pristine. And of course, women get left holding the bag with predictable results. RBG is often called a sameness feminist, and as if all she wanted to do was treat privileged women the same as privileged men. Often the alimony case is cited as evidence of that. First of all, that if you've read her early briefs, that just doesn't make sense. She uses the language of gender hierarchy constantly in her early brief. She does see gender as a hierarchy between men and women. But also what she realized is that if you give a benefit like alimony only to women, what you do is police men out of caregiving roles. And in her view, that was going in exactly the wrong direction. Now, the alimony revolution turned out to be a raw deal for women. That's very clear. But I think it's because the new entitlement replacing traditional alimony was designed wrong. It was designed based on need, and that has not worked out well. What it really should have been designed around is somebody whose career was marginalized due to the care of children, whether they're male or female. If alimony had been designed that way, we wouldn't have had the negative effects that we have now seen from alimony. And what Ruth Bader Ginsburg recognized is that she was really what I call a reconstructive feminism feminist rather than a sameness feminist, because she talked not just about allowing women into roles designed around the bodies and life patterns of men. She talked about the need to restructure that ideal worker to take account of the fact that many adults have caregiving responsibilities and at the same time need to perform as responsible and committed workers. She talked about the need for comprehensive childcare. So she really talked about going beneath the breadwinner homemaker norm and reinventing a new vision of an ideal worker who was an adult with childcare responsibilities and restructuring the world in the way that you would have to in order to deliver equality according to that vision. The irony is that when Ruth Bader Ginsburg did not resign during the Obama administration, it was extremely controversial. And one of the reasons she didn't is because she saw Sandra Day O'Connor resign from the Supreme Court before her and really lived to regret that decision. And I have been thinking so much of Ruth Bader Ginsburg. I mean, I don't know if Radhika agrees, but I feel pretty certain that because Ruth Bader Ginsburg did not resign, we're going to see the overruling of Roe v. Wade within a year. And I just think how pained she was in her last days because she well recognized that. And I do think, and I've written in the New York Times, I won't go into it here, that we ultimately, the path forward could be a better one for that, even though I'm mourning Roe every day of every week. But I wanted to end really briefly with something that Ruth Bader Ginsburg would have wanted you all to know, which is, as Scott pointed out, the only reason Ruth Bader Ginsburg was who she was because of the support of Marty Ginsburg. And so young women have been asking me, like, how do I find a Marty? And I think you go back to Olof Palme and the original feminist theory that inspired Ginsburg. It doesn't matter what your boyfriend thinks about women and equality. That is not where the action is. The action, what matters is what your boyfriend believes about men, about who is a man to be reckoned with, who is a good man, what is the role of a good father in the daily care of children. Folks, that's how I found a Marty.
Wow, thank you very much, Joan. And I mean, if I had known about that ending, I think we could have added some more marketing materials to our advertising for this event. A little extra there. So great, thank you very much. And we'll now turn to Professor Joel Paul.
Joel, you're
Joel, you're
muted.
muted. You're muted.
Sorry, I said that I'm going to sort of shift the focus a bit and talk about what comes next in terms of the Supreme Court. I think that right now we are facing a legitimacy crisis on the Supreme Court. It's a crisis because people are coming to believe that the court is no different than a super legislative branch. It's simply divided between two sides that are as polarized as any other legislative branch in the country. And that, I think, poses a threat to the court's legitimacy and to the way in which we regard the court's decisions. It's not that the confirmation battles are more contentious now than they have been in the past. In fact, beginning with George Washington and his nomination of John Rutledge as Chief Justice of the Supreme Court to replace John Jay, there has been a long history of very contentious battles in the Supreme Court. Rutledge was rejected because of a speech he made, because of his political beliefs about the Jay Treaty. And Jackson nominated Tawney to be an Associate Justice of the Supreme Court. Before he was nominated to be Chief Justice, he was rejected by the Senate as being basically too close to Jackson, too much of a Democrat to be appropriate to sit on the Supreme Court. A year later, he was then nominated to be Chief Justice, and unfortunately, he was confirmed for that position. Probably the most contentious of all Supreme Court battles until the modern era was when Woodrow Wilson nominated Louis Brandeis to the Supreme Court. Brandeis was known as the people's lawyer. He was famously an advocate for labor rights. And people like the president of the American Bar Association, former President William Howard Taft, the New York Times, the Wall Street Journal, all condemned Brandeis, saying he was much too extreme. He was a radical. He didn't fit on the Supreme Court. This was the first time in our history that there actually were Judiciary Committee hearings. And those hearings lasted 4 months. For 4 months, the Judiciary Committee had hearings about whether or not Louis Brandeis was too extreme to sit on the court. And eventually he was approved, but with 22 negative votes. In the modern era, really, the battles over the Supreme Court did not start with Clarence Thomas or with Robert Bork. They really started with Abe Fortas. Lyndon Johnson nominated Abe Fortas, who was then an Associate Justice in the Supreme Court, to become Chief Justice. And Fortas was lambasted by the Republicans led by Senator Thurgood, Senator Strom Thurmond, who accused him of being a pornographer, of basically favoring pornography. And to sort of make the point more vivid, he famously organized a showing of pornographic films in the basement of the Senate, films that had nothing whatsoever to do with Abe Fortas, to demonstrate to the media the kinds of movies that he thought that Abe Fortas would permit if he were confirmed as a Chief Justice of the Supreme Court. So these battles have been going on for some time. That's not why I think there's a legitimacy crisis in the court. What is different now is we have the development of really a kind of judicial confirmation industrial complex of multiple organizations pitching literally $1 million budgets to try to sway members of Congress or members of the Senate and the public by really attacking judicial nominees. At the same time, we have this litmus test that is really the creation of Roe versus Wade. In many ways, Justice Ginsburg's predictions about Roe proved true because it has become the sort of the binary test of every nominee to the court as to whether they support Roe or will oppose Roe. And at the same time, there's been a kind of a willingness to bend the rules. It used to be assumed that people who were nominated to the court were people who had a pretty established history of, as a judge or as a scholar, demonstrating their fitness for the court. And in recent years, we've seen this move towards younger and younger justices being appointed to take advantage of lifetime tenure. There's also been this effort to choose people who have been properly vetted by organizations that have extreme ideological points of view. And so we have justices who are perhaps less likely than justices in the past have been to move around, to change their views about the court, to have views that evolve over time. People like John Paul Stevens. Today, I don't think John Paul Stevens could get confirmed to the court. His views weren't extreme enough. He wasn't enough of an ideologue to be appointed to the court, but he was appointed as a conservative Republican whose views over time evolved, as did Justice Souter, as did Justice White or Justice Stewart. There's a failure to hold our truths lightly. And that's really the essence, I think, of the legitimacy crisis. All of these people being put to the court have been they have a platform. They're acting as party hacks. They're just doing the roles of playing party partisans. And that is not helpful to our democracy. So what can be done about this? I mean, how do we address the problem? In the last few years, we've seen this bending of the rules, in this case by the Republican majority, taking away the filibuster rule, which to some extent, it forced presidents to have to choose nominees who were centrist enough that they could have at least 60 votes in the case of a cloture vote. And most recently, we saw the McConnell rule, which really had neither precedent nor principle behind it, but Senator McConnell blocked the nomination of Merrick Garland, insisting that presidents in their last year in office shouldn't be nominating Supreme Court justices. Well, it turns out that no fewer than 10 presidents have nominated no fewer than 20-something justices in their last year in office. In fact, there are 14 justices who were nominated in the last 6 months of a presidential term in office. There were actually 7 justices who were nominated to the court in the last 30 days of a president's term in office, including Chief Justice John Marshall. And both George Washington and President Andrew Jackson, appointed someone to the Supreme Court on their last day in office. So the McConnell rule had no historical precedent. There was no basis in principle there. And then as soon as he was successful in blocking the Merrick Garland nomination, we see that Senator McConnell has stripped away this McConnell rule and changed the rules again, taking away the filibuster rule, taking away the McConnell rule. This kind of rule changing is not healthy, I think, for the way that we view the court. And I fear that it has invited retaliation by the Democrats in the form of this threat that is now hanging over us of court packing. I don't think that court packing would be healthy for the court either. I think this escalation in the polarization of the court is bad for our country. It's bad for democracy. It's bad for the court and for the Congress. So what is to be done about it? First of all, I think it's possible that the leaders of both parties can get together under the threat of court packing to try to find a way to reinstitute something like a filibuster rule that requires more votes than a mere majority. Secondly, I think it's important that the Senate resume the role it once had to advise the president as well as to consent. That I think that if there were some kind of a vetting process that required leaders of both parties in the Senate to participate actively in the nomination of candidates, we would tend to choose people who are more towards the center, who are more in the mainstream of judicial philosophy. And thirdly, I think that it is important to now consider term limits. That would require a constitutional amendment to the Supreme Court. But certainly when the framers originated the idea of lifetime tenure for Supreme Court justices, people weren't expected to live beyond the age of 60 or 70. Today, we have people being nominated for the court who are in their 40s, who are likely to be on the court for another 40 years. And it's that concern about the length of their tenure, which I think escalates the tension on both sides over each and every confirmation battle. Whether you agree or disagree with Judge Barrett's philosophy, I think that she is a classic example of someone who has very strong views, who has made those views known. And there's a certain irony here, and this goes back to the points raised by my colleague Radhika Rao. Justice Ginsburg warned us that Roe versus Wade would shift the theater of controversy from the state legislatures to the Supreme Court. And it has had a very polarizing effect. It is entirely likely, and I agree with Joan Williams on this point, that if Judge Barrett is confirmed, that it's very likely that the court will overturn Roe, or at least so restrict Roe as to render it meaningless. And that will have the effect of shifting the theater of action back to the states, back to the state legislatures, where I think people who favor abortion rights, as I do, should properly focus their energies in the future to address those issues at the state level, rather than expecting the Supreme Court to rush in and rescue us. With that, I'll turn it back to you, Jodi.
Great. Thank you so much for a fascinating and provocative presentation. And with that, I'm going to open it up for questions. So I'll go ahead and look for hands. If you can just use the hand raising function in your Zoom. We're very interested to hear your thoughts and reflections and any questions that you have.
Or if some of you want to type in the chat.
Yeah, the chat's fine too.
Oh, there's a hand.
Great. Rory.
Wasn't necessarily excited about appearing in person. Thank you very much. I thought the remarks were great. I just want to put a marker down, and I've talked to Professor Williams and Radhika Rao about this, but I've also talked to my Con Law 2 class at some length about this. It may be true that Roe is about to be overruled, although I wouldn't count on anything for certain. Things could still happen between now and confirmation. But it's worth fighting for. It's not the constitutional right recognized in Roe, which Professor Rao mentioned, is so important to so many other areas of constitutional law. It is so central to the right to privacy and the cases that grow out of the right to privacy, the right to intimate association. It is relied on directly in Obergefell, the same-sex marriage decision. And so, Justice Ginsburg never in her 27 years said she regretted Roe or she thought it was wrong. And I hope people will still fight hard to preserve it, whether Judge Barrett is confirmed or not. It's worth preserving. That's my only comment. Thank you so much for everybody's remarks. I thought were great.
Thanks, Rory. Joan and Radhika, do you want to respond to that?
Well, so I agree with Rory and Joel that, Roe is, I clerked for Harry Blackmun, who authored Roe. And I cannot understate the importance of Roe, but unfortunately, I actually feel like Roe is already gone in many ways. Planned Parenthood against Casey isn't really Roe. Planned Parenthood against Casey purported to adhere to the quote essential holding of Roe, but all they kept was the viability line. They got rid of the trimester framework. And the undue burden standard, as I said in the Supreme Court review panel, I think is an empty vessel that basically you can read into it pretty much whatever you want to read into it. And if you read Chief Justice Roberts' opinion in the latest Louisiana abortion case, he would read that standard as creating a really high threshold before a law would be struck down. It has to pose a severe, a really substantial obstacle. That's the way he interprets it. So unfortunately, I think we already actually have, even without the loss of RBG and the appointment of a successor, Amy Coney Barrett, if it's her, I think we already have 5 votes to essentially disembowel Roe versus Wade, but from within. So in some ways, and this is what I know Joan was getting at in her editorial, that we have the worst of both worlds, or the worst of all worlds, because we have Roe in name, in theory, but in terms of substance, we don't really have Roe. Now, I don't know. I mean, I still don't want Roe to be overruled. I want to keep Roe, but I think we have to concede that we don't really live in a world where Roe exists anymore already.
There are no abortion providers in 90% of American counties, and 95% of abortions are provided in clinics. There's no clinics in 90% of American counties. So, I mean, you know, Roe is gone. The only question is whether it's going to be overruled outright, which I actually think it will be now, or whether we're going to continue the death by 1,000 cuts, because Justice Roberts' concurring opinion in the June Medical Services opinion of last year basically said, okay, I'm not going to be so brazen as to reverse a decision we just made 4 years ago, because I have respect for precedent. But basically, give me anything else and I'm game. You know, Roe is, we have to realize that what we have now is access to abortions that is very delimited by geography. Now, I think if Roe is actually overturned, we will have access to abortion delimited by geography, but it will be, I believe it will be a lot worse, because I think many women will have to travel much further if Roe is overturned. But I think that we have to realize that the left has lost in many ways, to a very substantial extent, the access to abortion battle.
And access to abortion, I might add, is limited by geography and by economics. So
well, that's the same, Radhika, you know, and also they have these counseling statutes where you have to go and get preached at, and then you have to go, and then you have to come back like 18 to, I think it's 18 to 36 hours later. So if you're a low wage worker, you have to make 2 trips and take 2 days off work. And that's assuming that you don't have a day's drive each, you know, it is the same. Geography and class are, you know, access to abortion limited by geography is access to abortion limited by class.
It's striking to me also that the opponents of Roe have invested so much time and resources to affect the composition of their state legislatures. They have elected people to the state legislatures that have routinely used Casey to enact regulation after regulation to restrict Roe, while people who are proponents of Roe have largely ignored the state legislatures and have focused their energies more on, you know, who becomes president. And the reality is that the president can't really change the law. He can't have any effect on the law. He may be able to decide who gets appointed to the Supreme Court, of course, but that is only an indirect effect. It's the theater of action, the theater of concern has to focus now on what happens at the state level.
Great, thank you. So I see that we're nearing the end of our scheduled time. I know that many of our panelists are happy to stick around. Certainly anyone that needs to wrap things up should feel free to go. But if there are other questions, we're happy to take them. I see Richard's question in the chat, but I just want to make sure that that we get in any other questions from our attendees. If students have questions or any alums who are with us, are there any other hands out there? Okay, so I'll turn to Richard's question if folks can stick around for a little bit. Richard asks, how do you predict a 6-3 conservative court would respond to a Democratic Congress and president? Are there particular issues that you have in mind, Richard?
No, I just think that if we look at a broad range of subjects, I could see how a more conservative court could easily strike down a lot of things that a Democratic Congress might and president might try to do. But I would just leave it up to
So
you.
you're asking, sort of what issues do you anticipate might arise, and what would the 6-3 court do? And can I actually piggyback on that, particularly in light of the expertise we have on the panel? I'm interested to hear ideas about jurisdiction stripping, which is another sort of idea that's been floated to address the kind of, I think, issues that Richard is anticipating.
If I can just jump in, one of the things that I think is most significant about this appointment, and one of the reasons why, leaving the McConnell rule aside, discretion, prudence would suggest that the Senate should wait until after the election to confirm anyone to the Supreme Court, is that the election itself is one of the first issues that's likely to come up before the Supreme Court. There's so many cases that are now bubbling through the federal courts concerning the way in which we vote and how the votes will be counted and whether ballots will be counted after November 3rd. And all of those questions are very likely to come up to the court. And having the President of the United States, who is himself impeached, be able to influence the court by having appointed 3 justices who are seemingly marching in almost robotic ways along partisan lines, is, I think, very troubling and again challenges the legitimacy of the court, undermines the legitimacy of the court.
Well, in response to that legitimacy question, Joel, I think that's why Chief Justice Roberts is actually incredibly brilliant, because he finds ways to try to create this public persona of legitimacy where it looks like he's adhering to precedent, but he's very cleverly disemboweling it. So I think he's actually much cleverer than many of the other justices who would want to overrule Roe or other cases. He won't need to overrule them. He'll just disembowel them from within.
Well, and his vote won't matter any longer because he was the swing vote. And if Judge Barrett is on the court, he no longer becomes a swing vote. He can vote with the liberals and still they have a 5-4 majority.
Yeah.
Any other thoughts?
I just have a brief question, and then I know we have to wrap up. I would be interested in hearing the constitutional experts, of which I am not one. What's going to happen to things like the Affordable Care Act? Are we going to have another Lochner type situation where you're going to have the court systematically striking down social legislation?
Yeah, that's another really important issue that is going to be argued before the court November 10th. 4 members of the court have voted in the past to strike down the Affordable Care Act. The question before the court now is a kind of a technical question about the severability of the provision regarding the taxes. I think it is I just find it a kind of laughable position that they're taking, that somehow because they've taken away the tax power, they've taken the tax out of the act, that Congress doesn't still retain authority under the interstate commerce provision, but because Roberts didn't say that the law relied on the interstate commerce provision, they're now trying to use that argument. I just find it a hard argument to swallow, but I do think there's a genuine risk.
Also, Barrett has also said that she doesn't agree with Roberts. I mean, it's a pretty intense situation.
Right. And so I think that unless one of the justices like Kavanaugh or Gorsuch were to switch their vote, were to say that, well, even if I thought that the mandate was unconstitutional, I don't think that, I still think that the law can be severable. I mean, the Affordable Care Act is in jeopardy, and so are the lives of millions of Americans who have pre-existing illnesses, and specifically those Americans who have contracted COVID at some point in the past, who may lose their insurance coverage.
Well, on that cheery note, Jodi,
I think it's time to wrap up. I really do appreciate you all staying a little over. I appreciate everyone else for joining us, and I hope that you'll continue all these conversations with one another, with your colleagues, with your professors, and we'll see you back here next time. Thank you.
Bye-bye.
Thank you, Jodi.
Bye.
Thank you. Bye, everyone.
Thank you, Jodi.
Thank you, Jodi.
Yeah, thank you. Thanks so much to the panelists.